right. Welcome, everyone. This is our presentation on the legal ethics of client-led work. We are the Sustainable Economies Law Center. We are a worker self-directed nonprofit legal organization working on supporting people who want to return the resources back to the communities. And my name is Tia. I'm one of the staff attorneys at the Law Center. I use she and her pronouns, and I'll let my coworkers introduce themselves.
Awesome. I'm Ari. I use he, him pronouns, and I'm a staff member at the Law Center. I work on our legal land teams. I work with our Indigenous clients and our unhoused clients mostly. And I'll pass it to Erica.
Hi, I'm Erica. I also work mostly with our land and Indigenous clients, and I'm a staff attorney at the Law Center.
Could you also just say real quick what client-led work means?
Yes, so this is our take on movement lawyering. It's an approach that centers the needs of our communities and kind of rejects the traditional risk aversion that lawyers are known for. So we have deep ongoing relationships with our long-term clients where we work with them over the course of years and adapt our services to their needs. We might scale up when we don't know something or have clients sign conflict waivers to deal with messy, intertangling relationships or kind of push the bounds of what's allowed under a given law. And we try to set realistic expectations for our clients about the consequences of different actions, but also think creatively about how to make their goals happen.
Thanks, Erica. And now for our clients to introduce themselves, I'll start with Sawalmem and have Palm go first.
Tuyed pom pahato, ni and boss. Hello, my name is Michael Preston. I'm introducing myself in my Wintu language from the Winnemem Wintu tribe, Mount Shasta area, McCloud River watershed. And pass it to Melody.
Hi, my name is Melody here in Winnemem Lands and working with the Winnemem and with Palm and with Selk to start up and develop and utilize Sawalmem, which I'll pass it back to Palm if it's time for introducing Sawalmem as well.
Yes, thank you.
Okay, yeah, Sawalmem is a brand new organization we first formed with Selk's tremendous help in helping us getting off the ground for Sawalmem. But it's a nonprofit 501c3 unincorporated association with church status. And the purpose of this is to hold sacred lands in land titles and to continue our prayerful ceremonial cosmologies on these lands through a legal context. And Selk has been very instrumental in helping us translate that language into legal terms. And we're trying to do a whole lot through this, but that's in a nutshell.
Thank you. And we are also supposed to be joined by Tiny from Homefulness, but I don't see Tiny here yet. If Ari would like to give a 2-second elevator pitch about Homefulness, we could do that before moving on to some of the questions we'll ask our clients.
Sure. Poor Magazine is a poor people, unhoused people-led movement media project and also land project with unhoused people building their own homes that will remain permanently free for unhoused people for generations.
Awesome. And so you can all imagine that Tiny is very, very busy, and we would love to offer some grace in her lateness. But we could just start with asking Sawalmem first. How has it been to work with us, the Sustainable Economies Law Center? And what does it mean to you to have a client-led movement lawyer?
It's been amazing working with Selk, with you all. You all are very patient in us and in our trying to understand how the land works and operates through this brand new organization, and us just barely learning how to do this. You have been very instrumental, like I said, in helping us understand the concepts of what we need to understand as far as like land challenging land policies and putting implementing church status on a land. Like we didn't even know what that meant or how you even do that. And so that's been very interesting, but very, very powerful in that you have helped us in the ways in which you have. Very patient, very, very understanding in our indigenous ways of trying to be on the land. And it's been a very, very smooth process at the end of the day. It's been very smooth with working with y'all, I would imagine, compared to other legal firms or law firms or any kind of other lawyers that aren't really understanding of how land operates within an indigenous context and time frame as well.
Awesome. Thanks for that, Palm. Tiny is here now. We'd like to give you an opportunity to introduce yourself, Tiny, and like an elevator pitch about Homefulness or Poor Magazine.
Sorry, guys. This is one of those days. Do you hear me now?
Yes.
Yeah. Okay. Well, I always start by saying, do you see us houseless mamas and daughters sleeping in these tents? Do you see us houseless mamas and daughters sleeping in these tents? That's because we don't got money for the lie of rent. I'm a poverty scholar, that houseless mama, that houseless daughter. All those people they don't want to see, never want to be, look away from we. What you gonna do? Occupied Ohlone Lashawn land, Devangar, settler colonial shitty, arrest we? We're in your city. Yeah, it's a little bit of my slam bio. And we say that we poor people built these homes with a poem. We're all houseless, formerly houseless, poor people from all different parts of Mama Earth, all four corners. Myself, I'm part Afro-Taino from my mama, and on my dad's side, straight colonizer. And me and Ma ended up on the street when I was 11 years old. And it was necessary that I drop out of institutional um, forms of education and enroll full time in the School of Hard Knocks, where I'm glad to say I graduated with a PhD in poverty. Not because there's anything glamorous about that, it almost killed me, but because these are the ways that I learned. This is the way I learned law. This is the way I learned to navigate a system that is set up from the get up to incarcerate every poor person it gets. And similarly, this is what I learned about, I should say, how my body didn't matter to this state, how my body was worth more if I was incarcerated, worth more if I was non-profiteered and managed and case mangled and anti-social worked. So from that car, from that doorway, from that moment, that impossible life, me and my mom dreamt of a dream called homefulness, a homeless people's solution to homelessness. That mama festation is now happening in Deep East Uchun. And we have our 22nd houseless family who just moved into rent-free forever housing on Friday. I could say a lot more, but maybe I'll leave it there.
Yes, thank you so much. That's amazing. Would you also like to answer how it has been to work with SELC and what it means to you to have a client-led legal team?
Yeah, I mean, that's a really powerful and interesting concept. And I do want to name a couple pieces that I often say that I'm a jailhouse lawyer outside of jail without a degree. Actually, let me amend that. I'm a jailhouse tenant lawyer. And I learned and passed my own bar exam, if you will, by surviving 22 evictions. When me and Ma were on the street, sometimes we'd get enough coins together to go inside, but we didn't have enough to stay inside. My mom was disabled. She dealt with trauma from her life as a mixed race child, unprotected in orphanages and torture homes, as she called them, foster homes, and was unable to continue to function within a capitalist system. So that's why it was necessary that I work, and we were vendedores, somos vendedores. I bring all that up when you ask me this simple question because throughout the whole years of Poor Magazine, which is the roots of Homefulness, it's a poor people-led, Indigenous people-led movement. We might have access to that paper because we noticed that folks with race and class privilege are afraid to give resources to poor people unless you have a piece of paper between you that somehow gives you American legitimacy within a legal system. But throughout our entire time as poor people, we always needed lawyers. We're always enmeshed dangerously with the state, and we could never, get any support. Ocean Newman, a revolutionary lawyer, broke me out of jail after I did 3 months for the act of being houseless, which is a citable and arrestable crime. OSHA, in some ways, became somewhat of a legal mentor for me because I knew a lot of things, but I didn't know the relationship between a papered lawyer and what that meant in the injustice system. When we started Homefulness, poor and houseless people didn't have 2 coins to put together. Buying because of folks with race and class privilege, radical redistribution, buying small parts of Mama Earth, and then building Homefulness in solidarity. We built it, and they supported us in solidarity. We always needed a lawyer. Once again, we needed a lawyer to deal with contracts, as I call them. We deal with the shitty settler colonial governments and the shitty halls, and we never had one. And we actually tried to get client-led lawyer groups before, even Selk, to be very perfectly honest. I'm not quite sure what changed over the years, but 10 years into it, we were approached by Janelle and some others saying that, we'd won the lottery, and now we were going to be supported by y'all. And I say that jokingly, but not relatives. The fact that you guys stand with us is the fact that we were able to get the shitty settler government off our neck. The boot was lightened off of our collective necks. They were never going to let us poor and houseless people build a solution to homelessness. Never. And for any of the other relatives on here know the herstory, the violence of literally blocking us for 11 years and the permit gangsters. So because you all stood with us and navigated your legal privilege, because you went to people school, because you listened and really took in the notions of poverty scholarship informed legal support, I do believe that it is one of the reasons that Homefulness exists today. And that's how huge that kind of navigation and leveraging of race and class privilege can be for people who are intentionally shut out, left out, and incarcerated. These are absolutely revolutionary ways to operate within a system that is intentionally trying to kill us. And so I just thank you guys from the bottom of my toes to the top of my head.
Thank you so much, Tiny, for all of your work. Yeah, and we have a bunch of our legal fellows here, and we're trying to help spread this kind of legal work. And part of that is by providing this mandatory continuing legal education credit on the legal ethics of client-led work. And the way we're going to do that is we're going to go over some rules so that y'all can get your credit. I'm going to share my screen. Eventually, I'm going to share this one and turn it into a Sorry. Okay, presenter view. So this is, the legal ethics of client-led work. And what we're going to focus on are 3 legal ethical rules. One is the duty to act with zeal, the other is conflict of interest, and the other one is competence rules. And first I'm going to go over a rule, and then maybe I'll give an example or two. And then I'm going to turn it over to our clients and my coworkers, Erica and Ari, to discuss how those rules apply to client-led work. So the first rule we're covering is about zealous advocacy. We're taught to be zealous advocates in law school and culturally on TV, but in California, no statute or rule actually imposes a duty of zealous advocacy. The ABA comment to model rule 1.3 instructs that a lawyer act with zeal in advocacy. But when California adopted this rule, we removed the word zeal. Still, it's generally understood that we're supposed to represent our clients zealously, and there's case law to validate that. But even that case law mostly emphasizes the limits of too zealous advocacy. So, for example, in Hawk v. Superior Court, the court noted that our duty is to represent our clients zealously, but within the bounds of the law. And Business and Professions Code Section 6068 lists a bunch of duties we have to our clients, but only after first mandating that we support the Constitution and laws of the United States and of this state of California. And then there's the California Rules of Professional Conduct. Rule 1.21 basically says that we're allowed to counsel a client off the ethical ledge if they appear to have a criminal or fraudulent objective. But there's a critical distinction between presenting an analysis of questionable conduct and recommending how a crime or fraud might be committed with impunity. And depending on how long you've been a lawyer in California, this rule might seem stricter than when you took the MPRE, and it is because in 2018, the California Rules of Professional Conduct were revised. And this rule used to say that if a lawyer believed in good faith that a rule or ruling was invalid, then they could advise a client to violate that law. And Michael T. Pines is a lawyer who got in trouble, perhaps because of the ambiguity in the pre-2018 rules. He was an anti-foreclosure attorney who maintained that the vast majority of foreclosures are illegal. He was arrested several times after breaking into his clients' foreclosed homes, claiming that the foreclosure was invalid, and therefore his clients had a right to go back in. So he was arrested and he has also been disbarred. And the current rule, 1.21, no longer allows us to decide whether a law is invalid. Now we must refuse to counsel or assist a client in any action we know to be against the law. But it is permitted that we discuss legal consequences or to help a client make a good faith effort of their own to determine the validity of the law. At SELC, this is important because sometimes our clients want to engage in civil disobedience. And comment 4 to this rule authorizes a lawyer to advise a client on the consequences of violating a law as a means of protesting another law or policy the client finds objectionable. So I would like to turn it back to Tiny and have you answer what the role of civil disobedience is in Poor Magazine's work, and how has SELC helped you assess the risks of certain actions?
Sorry, guys, I'm moving in and out of different rooms, and so my signal is going down. So it's an interesting question, and I also want to say that it's very complicated because we understand that you're walking that fine line. We have a ethic, a value at Poor Magazine that we I don't know if we even call it civil disobedience because I don't know what civil even means, nor do I understand disobedient. I think these are all, terms rooted in white supremacist carceral state, but I understand that's the words that the state uses for resistance, right? So to me, it's always about questioning and unpacking that language too. But I wanted to name that we believe that poor people, poor and houseless people specifically with no family, no money for a lawyer, no resources, and oftentimes having a jacket, having a record. I said we needed a milk.
Yeah. You want to get it for the store?
Huh?
You want to get it for the store?
If you don't have any at home, yeah, get
don't
one.
have any.
Okay, get
Yeah.
one. You need money? Sorry, guys, we're doing three things at the same time. We just don't believe that folks should put themselves in a position of more danger. One of the things I often teach is poor people are never safe in the US. And so even this idea of safety is kind of a false narrative around for poor people because our lives are interrogated when we try to get a EBT crumb, when we try to, get a shelter bed, when we try to do essentially anything. And so if we intentionally put ourselves in unsafe positions, it actually doesn't even really make sense. We had a situation like that where one of our relatives were caught in a whole thing, and they were being led by middle class people who, as my mama D would say, never missed a meal, folks who never understood the ideas of actual suffering in a lot of ways, but just believed in activism and all that. That's just great. It's all good. Yay. I'm glad for you that we have to change the world. Let's do that. But those aren't ways that operate with eldership or with overstanding of what the class and race differences are for different communities. And so it doesn't make sense for our folks to put themselves in a position of more unsafety. I mean, we won't stop anybody from doing that, but we're very, very clear about the very, very real risks of being arrested and what that means. And it's not just something to do. Some of our folks got charged with RICO, caught up in that thing that I was referencing a second ago. And that was a $350,000 felony charge. And they had no way of fighting that. And, there were this was a little bit before, this was like late 90s, and NLG didn't really launch a lot of their work that they are doing now. But they were lawyers, and they weren't willing to, they were willing to do a certain amount. But when it came down to it, these guys were on their own because they had no resources. And all they had was us. We're more unresourced people. So it's a very dangerous thing. It's a slippery slope. And I say that to say that it's another reason to be very clear about our positionality in movement work. If you're someone with different forms of race and class privilege and you overstand those risks, and now with the orange colonial monster, I don't even know if anybody should be doing that, to be real, but that's another conversation. But if you understand that and you also have perhaps a trust fund or a family with some resources or somebody who has a house, you're not going to be absolutely lost in that system, which many of our folks are.
Thanks.
Sure.
And has Selk helped you assess any of the risks of certain actions?
Oh yeah, definitely. I mean, we've talked about it, and we just did a Know Your Rights training yesterday, and Selk was part of it and supported in that. This is a lot of criminal stuff or whatever, which I know isn't in Selk's sort of options or portfolio or whatever, but they have been helping us think through that when it regards Mama Earth liberation, in regards to the things that we're doing on Homefulness 1 and 2, and our engagement with the city. And it's been very helpful and very powerful.
Yeah. All right. How about you, Sawalmem? What are some challenges we've navigated together?
some of the challenges that we've had and run into with this whole thing with us is like, of course, involves the land and how to put land titles into a quote unquote church status with unincorporated association status as well, all the 501c3, all that language, and interpreting that to the counties of Shasta County where we're at, and the land title holders, and also I guess just like orgs, people in general too, just have a hard time. It's been a difficult time wrapping that message up in a bundle for people to understand and to give it respect, I guess you might say. We're trying to push our spiritual belief systems through this organization, which is a spiritual land-based, I guess you can call it like as a belief system, spiritual tradition, but through a church reinterpretation, and trying to have that aspect of the land being sacred, water sacred, everything being sacred, translated through a church status and have it be valid for the communities of Shasta County in particular. That has been a difficult thing that we've run into. If there's anything else you'd like to add to that, Melody, or anything that might be coming up as well, please jump in.
I think I'm thinking in relation to kind of what you're saying, some of the challenges of translation, and how to operate from within. I think it's one of the strengths, and we can maybe speak more to it later in terms of competencies, but how to translate things in a way that actually centers Indigenous cosmology and way of believing, and then works with the law in how to enact that reality within in a way that is still legally compliant so as to protect the community, rather than asking, there was a kind of a instance comes to mind of this translation capacity that Silk has for being able to translate things into the system, where we were working with the IRS designation for a church, and we were running through all of these questions, and sitting with Poem's mom, Chief Colleen, and even the framing and the phrasing of the question, she was coming back with like, we don't what it not making sense in the context of a Winnemem cosmology. And then Selk retranslated all of those questions and brought them back in the form of, rather than a question like, do you have a literature, an official church literature, instead asking the question, how is the worldview translated to future generations? And then, of course, Chief Colleen had tons to say about all of the cultural capacities that are in place and all of the cultural practices and ways where that is happening. But I think this challenge of staying rooted within Winnemem cosmology and then utilizing the law in service to that, rather than asking Winnemem to translate, rather than asking Winnemem to go the other direction around and compromise sovereignty again and again in order to fit these definitions. But even just working with the tax assessors, this piece like Poem is talking about around the sacredness of the land, to be able to translate that Winnemem usage of land is a religious activity, and like working with all of the agencies and different departments to massage out this like rigid attachment to church as a building. Even just that piece, I feel like, is one of the challenges that we've navigated and had to like work that again and again and offer these iterative translations of what a church means rooted in Winnemem sovereignty, as opposed to a dominant colonial conception of what that means.
Thank you. All right. So we are just going to move on to the next rule, which is about conflict of interest rules. And let's see. So rule 1.7 outlines the conflict of interest rules and how to waive them. I'm going to focus on how to get informed consent from clients when we want to represent two separate organizations, even if there may be a significant risk of conflict of interest. So informed consent is defined as a person's agreement to a proposed course of conduct after the lawyer has communicated and explained, 1, the relevant circumstances, and 2, the material risks including any actual and reasonably foreseeable adverse consequences of the proposed course of conduct. In the handouts that I think Erica has sent everybody, on slide 7, you can check out 3 examples of ways to get informed written consent. One is the super long and thorough template from the state bar, but in essence, it lists the following risks when representing more than one client on the same matter. One is divided loyalty, diminished attorney-client privilege, conflict that may arise with regard to litigation strategies and settlement issues regarding custody of the original file, and risk that attorney may be disqualified from representing one or more of the joint clients if a dispute does arise. This is just an optional template to help lawyers get informed consent, which again is just a consent that a lawyer gets from explaining the relevant circumstances and the material risks. Here's a simpler conflict of interest disclosure that Selk felt was more relevant to the potential conflicts between our 2 clients, Sawalmem and the Indian Cultural Organization, or ICO. And ICO was Sawalmem's former fiscal sponsor. So this is an excerpt from a signed document. Here, instead of listing the general potential conflicts that the state bar recommends, we listed the kinds of conflicts that we've seen between fiscal sponsors and sponsees. And so I'm going to turn it back to either Melody or Palm. Can you say more about Sawalmem and how you relate to ICO, the Indian Cultural Organization? And do you remember how strange it was for us to go through a whole waiver process so that we could start representing ICO, and what was weird about it?
Yeah, first we represent ourselves as Winnemem Wintu people of the McLeod River, first as a tribal, historically, traditionally ran entity outside of all these colonial, like all the lawyerly, all the law, outside of the law. We're a traditional tribe that has traditions, and we're our dances and our ceremonies and our own rules and protocols around this that really leads us. And we're a fairly unrecognized tribe, so that means we're not a recognized. We don't have the legal status as fairly recognized tribe. There's a big distinction there. So we've had to go different routes to organize ourselves through, to advocate for us, and to funnel money through, get donations so we can operate our tribe as a people. So we formed ICO, which stands for Indian Cultural Organization. That was formed by my mother and her auntie, Aunt Maud, in 1983, and so it's been ongoing since, in and out of operation, but was operating before Sawalmem came into existence. And we formed Sawalmem in 2022, I believe, and it was brand new. And one of the ways in which we wanted to operate Sawalmem was many ways, but a big one was to hold land titles inside of, and to get the designation of a different tax bracket for land titles and whatever else that we would be afforded to us to continue our traditions through. And so it was basically, there was a conflict that happened in the 2 organizations, kind of operating. Well, I think Sawalmem didn't really have this issue per se. This is why we formed Sawalmem, not to operate under the traditional, quote unquote, traditional 501c3 board and all that, and voting. I don't know how but ICO was a traditional 501c3, and so they had this order of conduct, and people were kind of like believing in the order of conduct of a 501c3 rather than the traditionally tribal-led protocols of decision making. And that's where kind of the some of the issues came through, and we managed to work that stuff out. But this is some of the hangups that we ran into by forming 2 different organizations, and we had to. I think they wanted their. There was an issue. We were wondering if there was an issue that Selk had, or if the IRS or whoever had, with a law firm or Selk representing both of our entities, and if there was any conflict of interest in that. And people were kind of scared around that, and so we had to kind of navigate that and get it out of the way. I think it's good now, but that was a little bit of a learning curve and a transition phase for us as a tribe, and then to operate it as two separate, 501(c)(3)s. It's a bit complicated at times.
Yeah, I think part of what was so strange is like you have the way that this really simple question of ICO needing some support and Sawalmem having this relationship with Selk and it being like, oh hey, you all there is no you all. It is not actually an us and them kind of situation. And so to have to go through this whole process of creating all of this legal documentation so that Selk can represent, it's like Sawalmem and ICO are different expressions of the same vision. They're just carrying different pieces and holding different legal designations to move that forward. It was a strange process in the sense of, it's like in some ways there's overlapping people involved as well. And so the way that the legal frameworks create kind of like false animosities and assume the worst, and assume these terrible intentions between organizations, and then set up all of these mechanisms and go through all of these steps to ensure that there's no conflicts between them and what would happen. And even having to run through those things felt counterintuitive, and strange to be having to think about an organization that's actually a sister organization, that's actually a different expression of the same vision through the lens of, checking all of these boxes to make sure that that Sawalmem or that ICO are protected from each other. Was part of what I remember also being really strange in that process. All of the assumptions that are embedded in the framework of the legal requirements that really don't make sense in the context of like community-led organizations.
Awesome. Thank you. Yeah, I think that part of the awkwardness in the process of getting informed written consent from ICO and Sawalmem is how formal the whole process was, and how long it took. And I'm realizing now after, putting this presentation together that it didn't have to be that way. The Sawalmem conflicts disclosure was 2.5 pages long. And here is a half-page long email from our coworker Janelle to our client Homefulness regarding a potential conflict of interest with our other client, Segurite Land Trust. And I really love how Janelle's super simple email waiver made it easy for our clients to provide informed written consent. The one thing I would add is a warning that Selk might have to stop representing either of the clients in the event of a dispute. But other than that, this covers everything that we're supposed to cover to get informed written consent. Informed written consent does not have to be on a signed document like it was with Sawalmem and ICO. It can be made by email. The ABA model rules allow us to write a confirmation of consent that we obtained orally, but in California, the consent must be written by the client. And so here's an example from Tiny, which is also a super simple email of that provides informed written consent. It's just one sentence. And let's ask Tiny. Tiny, can you say more about your project with Segurite Land Trust and what is it like to partner with an organization that is also represented by your lawyers?
Well, I don't know. Let's see. Moving out of, the legal constraints of this panel and everything, which I guess you have to be in because you're trying to get that paper. So more power to you, revolutionary lawyers who are doing this. But Segurite Land Trust are our spiritual aunties and sisters and nieces and grandmamas, as a pan-indigenous movement, which we're from all different parts of Mama Earth, from several sides of the false colonial borders, and right here, people who've been in chattel slavery to build this lie called Americlan, and so many other relatives are part of what I call this violent unhoused nation. I personally don't believe that you can talk about homelessness and land without recognizing, honoring, and lifting up and asking permission of First Peoples of this land. That this is not free, that nobody owns this part of Mama Earth or any parts, and that, like any good neighbor, not not State Farm is there, but we need to ask permission, we ask the guidance, and follow protocol that's set from the relatives upon whose lands we're humbly standing, sitting, sleeping, trying to exist. And so when we started Homefulness, our first job was to ask for prayer and spiritual guidance, and involvement and permission from Karina and Janella and others in that beautiful movement, which they lovingly granted, and actually became part of our Elephant Council, which is the um, way that we make decisions. And why elephant? Because elephants are radically interdependent, just like us, matriarchal like us. And these are the ways that we make decisions and we make things move at Homefulness, and it's part of our ways of never engaging with the state. And we do a lot of teaching on how to not call the police ever, how to hold each other as traumatized people. This is not some cute walk in the park. We are all people coming from very, very severe forms of trauma, that either came from our experience in our lives, many of whom are First Nations folks, houseless on their own land, which is another insane hypocrisy of AmeriClan, of occupied Turtle Island, um, and also many people from all different nations, with different forms of skin privilege too. There's broken settlers, as I call us, broken white people too. Um, and so the reality is, when we sought that permission and that protocol and that spiritual guidance, we were already in relationship with Sigorte, and it was a deep relationship that continues to this day, and there can't be a homefulness without that model. Homefulness is actually working now with relatives in Tavanga, LA, so-called Pacific Northwest, Chief Seattle, and Ilamu, Frisco, to build in homefulnesses there, and the same model is being followed. But when this came up, one of the first things that we committed to doing is spiritually and legally unselling Mama Earth. This is some of my language, um, and in doing that, we're mostly worried about the settler colonial laws that we had to navigate. How do we, you know what I mean? How do we create a document that the state will respect? Land trusts are lies; they have an expiration date. And we aren't the first peoples of this land. So how do we do this work? And so we've gone through this really extensive process of learning how to navigate that system. And again, that's what Selk has worked with us on. And I had this dream, as I often have a lot of things in my dreams that has come from ancestors. My mom is very active from the other side in this movement, um, to create a land liberation act. And we worked with Janelle to do that, and we're still in progress of doing that, along with Karina and others. But in the meantime, we had to create some document. And so the document that actually Janelle helped us form was this idea of the land liberation easement, which were kind of my words, but then Janelle put a container, a thing to them, and borrows from the concept of the cultural easement that First Nations folks, I think, do, at least Sigorte had done. The difference in ours is that it's a meta legal document that is rooted in our stories. And when I say meta, I mean that it's also a metaphor, it's also a poem. It's her stories and his stories. And they're active and they're fluid and they're constantly changing. But how do we unsell Mama Earth in a system that is intentionally set up to buy, sell, profit, and extract from Mama Earth? How do you do that? So again, this process of creating this container was really deep and difficult for us because none of us know about legal stuff, and the language doesn't make sense for us either. It doesn't fit with the way that we function, and it's intentionally separate. There's language that is created up, I call linguistic domination, and it's some of what we teach on in the poverty scholarship textbook, which everybody on this call should get a copy of. Poor People Led Theory, Art, Words, and Tears Across Mama Earth. But poverty scholarship informed moves means that not only are we working with permission and protocol from first relatives from this land, but also we're recognizing eldership, we're honoring survival knowledge, we're honoring the knowledge of our ancestors, and we're also honoring people's traditions from all four corners. I have a saying: the revolution will not be melted in a pot, whether you pray to Mama Earth or you pray to the church. And so to live by these visions, again, with traumatized, broken people, that we are trying to unbreak each other, which is very, very hard to do. We're always working and always holding and always caregiving. And it's really, really hard. And what Selk has done is that they provide that legalese, if you will, that those linguistic domination skills, leveraging into legal, language that's required for legitimacy, to be taken seriously, so that our next seven generations, my son's great 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 grandson or granddaughter, can't suddenly wake up one day and become a raging capitalist and decide to turn homefulness into, a luxury condo, right? How do you even do that? Because the laws support that move. I don't have to tell you all that. It's terrifying how they do too. There's like multiple laws that support that exact move. So anyway, in closing, Selk was able to help us build that liberation container, and that's what we're filing with the Southern colonial government, along with our prayer, our poetry, our painting. As poor people, we teach through many different ways, not a 30-page digital document that goes in your professor's trash can. We teach through our stories and our life.
Thank you, Tiny.
Mhm.
Okay, so the last thing I wanted to go over with regard to conflicts of interest is that a lawyer's political orientation can be a potential conflict. So conflict of interest disclosures and consent forms can also be incorporated into a legal services agreement. And here is an excerpt from one of our client engagement letters. It says, we are likely to steer you toward land ownership structures that ensure permanent community control and decommodification. We believe this is why you want to work with us on this project, so we don't believe that this poses any problem to our effective legal representation. Now my coworkers can finally talk. Erica or Ari, are there examples of ways your political orientation could have been a potential conflict with one of our clients here? How so? And I think Erica's going to go first.
Sure, yeah. So I think this is one of those things where it is really good to name it because of exactly what Tiny was talking about, how the laws do promote, capitalism. So for example, if we're doing something that limits the future profitability of land that our clients are getting, there's an argument there that that's not benefiting the clients, and that's actually a conflict of interest. But on the other hand, we know that our clients come to us because of the political orientation that we bring. So yeah, I think just putting it into the conflict of interest really waiver helps get everyone on the same page.
Awesome, thanks. How about you, Ari?
Yeah, this came up for us around intellectual property stuff in general. At the Law Center, we focus a lot on deprivatizing and decommodifying things like land and knowledge. And so our original orientation to things like intellectual property and copyrights and patents has been to focus on writing up loose agreements that describe why the automatic application of copyrights stifles collaboration and knowledge production and sharing. But working with our Indigenous partners, we learned about the ways that certain kinds of knowledge is sacred and is carefully shared through protected lines. Um, and that failing to protect that knowledge from universities and publishers that could stand to profit off of it and share it in ways that it shouldn't be led us to take on and work on drafting strong intellectual property contracts that were really protective of that information.
Thank you. All right. The last rule we're going to go over is competence. So the new California Rule of Professional Conduct 1.1 is very similar to ABA Model Rule 3-110. However, unlike the model rule, it defines competence as a negative, not a positive. It says a lawyer shall not intentionally, recklessly, with gross negligence, or repeatedly fail to perform legal services with competence. And it's noteworthy that competence is defined not only as learning and skill, but also mental, emotional, and physical ability. So I'm going to finally turn off these slides and ask Ari or Erica how, let me see, what was the question? What do you do when you're not feeling competent? Do you associate with other lawyers outside of SELC? Do you acquire sufficient learning and skill before performing, or do you refer the client out, or all of the above? Let's start with Ari this time.
Yeah, this also came up in the context of intellectual property stuff. One of our clients is working on an invention with the university that involves traditional ecological knowledge, which is something that we taught ourselves about, and then realized that there's not a strong way in which traditional ecological knowledge has been incorporated into intellectual property law. And so we realized we needed to find people that both had a specialty in traditional ecological knowledge and IP rights. And so we did a bunch of searching, both looked at our SELCS fellows, the people that we've trained and that we work with, and then online to find people in those specialties, and reached out and got a bunch of people together, had one-on-one conversations, and then brought them together with the clients.
Thank you. How about you, Erica?
Yeah, I would say definitely a combination of the different methods that you mentioned is the way to go. So as Ari talked about, bringing in other lawyers who do know the answers, whether that's just an email, as the SELC Fellows groups does all the time, or actually connecting your clients directly with them, as well as Dorian and I were doing, we wanted to partner with Agroecology Commons and advise farmers. And so ahead of that, we took a class through California Farm Link on business and legal considerations for beginning farmers. So there's these kinds of upskilling things that you can do as well.
So thank you, Erica. And to Sawalmem, what are some ways SELC has shown competence in ways that other lawyers might not?
What's coming to mind for me is, for one, this just a huge level of dedication and love, like an embodied practice of so much humility and the kind of creative capacity and dedication in the follow through, and the humility to pause and notice when there may be a gap in knowledge, and then a willingness to be in your own ongoing learning. As well as kind of what I think of as relational protocols, like relating in a way that actually in a way that exists beyond the framework of a relationship between lawyers and clients, that maintains professionality, but also actually practices a deeper form of relationality. And the form of the kind of collaboration that's able to grow in that space. I mentioned it earlier, but that translation capacity as well, the ability to not actually impose a framework of belief, but really listen deeply for what is there, and then consider the implications of the translation between kind of paradigms and knowledge systems and colonial legal framework and an indigenous world that I think, requires a lot of also depth of self-reflection. I feel like your competence as human beings to enact ways of relating that are reciprocal rather than extractive is a huge part of your competence in enacting the client-led work.
Thanks, Melody. To Tiny, I know that Poor Magazine has taught Silk so many things, and I want to give you an opportunity to share something that you have taught us that you think makes us more competent.
Well, I think a lot of what we talked about today is things that I've taught Silk. I do want to make a big shout out to encourage the lawyers or the lawyers in training on this in this workshop to come to People School. It's not that it's not a school. It's not Stanford. It's not Yale. It's the People School, and it's a seminar, degentrification, decolonization seminar. And no matter what you do, it's important to learn and unlearn the lessons of capitalism we've all been lied to in this settler state. And you don't unpack those lies through, you know, a 2 hour workshop that you guys are doing now, which I love it. And I'm glad you're doing it. But I want to say this is a lifelong journey to, to pull yourself out of the stew of lies that people, specifically people with privilege, are told. And I don't just mean, you don't race or class privilege, I mean formal education privilege. And so I just want to encourage people to think about coming to that. It's on Zoom. It's 2 days with 3 follow-ups on Zoom. So it's not a big chunk of people's time. So there's a whole lot that I feel like I've taught. And I know that people like relatives like Tobias and Ari have said that these are life-changing lessons, which I listen. I'm happy to hear that. And I know that I've watched them operate with poverty scholarship informed movements. And that these are things that we need to be processed and unpacked. And it's really a healing more than anything else. Legal systems, or legal education, just like medicine, are the linchpins of the system of colonization that we live inside of. They're absolutely necessary, and they're rooted in classist, racist values that are mostly unseen and some very well seen, but overt and covert, and they're multiple. And so it's a lifelong journey to kind of tease those out of your head, out of your actions. You can be a nice person and move gently and all of these kinds of things, and you can still be somebody who practices legal and medical apartheid. These are very violent systems. It's why we have an absolute open apartheid going on in the United States with these carceral systems. It's why we have thousands of elders on the street with no home. It's why we have babies on the street with no home. It's why we have thousands and thousands of people in eviction court right now, facing nothing and nowhere to go. Legal support is life in this system. It's a lifeline. So I take this very seriously. I would also encourage people to read the piece that I infiltrated, thanks to Mohit, into the Harbinger Law Review or something. I don't know what it was called, but Poverty Scholarship and the Lie, and hopefully more people can infiltrate my words into these spaces. I do want to say that intellectual property is the only property us poor people have. If you learn anything from me or any of us poverty indigenous scholars, please credit those back to the communities, because these are sacred knowledge, right? These aren't things that we're teaching because it's something that sounds good, or that it's, maybe makes for an exciting Zoom session. It's because we're dying. Over 6 people a day are dying from the violence, the colonial crafted scam called homelessness and land theft and eviction and the commodification of Mama Earth. So the work that we're doing here and the work that needs to be learned and unlearned is absolutely a lifeline. And I'm so honored and proud to stand with these young folks and with these folks, and also alongside, warriors like Winneman Wintu and Segorte, and just in terms of, unpacking the colonial legal system and remantling something that actually really ensures land back and ensures Black land return and ensures that Mama Earth is not for sale.
Thank you, Tiny. So we are out of time, but if you have to leave, then you can leave and you'll get the full hours credit. And we reserved the ASL interpreters for 15 minutes after the end time because I envisioned this might happen. And we just have 2 more questions, one for Ari and then one for Sawalmem again. So if you want to stay, feel free to stay. Ari, can you share what you've learned from Tiny?
Yeah, well, deep amounts of humility. I've learned how not to stop when I'm faced with a legal question, not to stop with a like, oh, these are all the reasons why this can't happen and it has to be done in this way. Otherwise, like, it's not gonna work. And to approach it more of like, no, this is going to happen, this needs to happen, and this is how we can make it happen. And respect for elders, and deep dedication to working with and supporting poor and unhoused people. And I can open it up to some other Silk, if any other Silk staff have been to people's school or want to share anything else.
All right. I'm not seeing our coworkers unmute, so I will just let Erica add something to what she wanted to say.
Thank you. And yeah, this is actually also gets to what I'm learning from our clients. But I wanted to say about competence. I think when we're acting as kind of like a general counsel for these clients and you know, taking a client-led approach to our work. And also when we're pushing the boundaries of what the law allows, it's not going to feel like we know everything and like we're competent all the time and we have all the answers. So I think just being honest with our clients about what we do and don't know, and then also reaching out to other attorneys is kind of the answer. So I'm thinking of our fellows network, and how I've, emailed and asked questions and then been met with resources that help improve the advice that we're giving, but also kind of help give us confidence that, maybe there is no clear answer to this question. So rather than shying away from that and taking the risk averse route, leaning into those ambiguities and making our best informed choices about what we can do within that.
Thanks, Erica. All right, and to close us out, to Sawalmem, what are some things that you have taught Silk that you want other lawyers to know?
What comes to mind for me is that basically, I think what we have to offer from Sawalmem is the indigenous worldviews, indigenous cosmologies, the different ways in which we interact with the land, all the ceremonies and how they interact with the land, how we run our people outside of organizations, some of the ways in which we regard water, these types of things that we kind of can offer, I think, to all people, but also in regards to the context of the law, like us Native people, we're always been interacting with the law in certain ways because we're political entities deemed by the federal government, and we're always dealing with the land. And so we're always going to be butting heads with the law, water law, land title law, all of them pretty much from the beginning. And so, especially in regards to the land and water, though, I think um, getting our voices heard in the sacredness of what land and water is and what we're really trying to do, and also the traditional ecological knowledge and giving that validity in relation to salmon restoration efforts. And just like there's all kinds of law that we're interacting with, all these federal agencies that we're interacting with all the time as well. And having good lawyers on our team is very much needed. And I feel like we're on a learning curve as well, as the laws and just like the world's changing at the same time. I feel like we're somewhat of messengers, you might say, from the land, from the water, from the salmon in particular. I think that's what we have to offer to, as a whole, indigenous people as a whole, to the lawyers and just all the world. We need to come together in a way and speak up for the waters as a whole. Something like that, though, I think what we offered to Soak, if you might agree.
Absolutely. Thank you so much. All right. Well, we are out of time. I'm sorry we don't have time for questions, but y'all know our email addresses. It's just our first name followed by @theselk.org. So Tia, Erica, and Ari @theselk.org. Thanks, everybody. Oh, and yeah, there'll be a recording. We'll send it out. Bye.